Position statement is being presented on behalf of plaintiffs Gene and Constance Vernon in the matter of Riot Foods against the defendants Lindsay and Luann Crane. The dispute at issue here today is whether the plaintiffs and defendants had formed a contract for the sale of plaintiff's business, Riot Foods. It is the plaintiff's position that under Section 2-204 of the Uniform Commercial Code, that a contract for the sale of Riot Foods was made with the defendants. Many of the facts at issue are in dispute between the parties. However, the basic facts are as followed. The plaintiffs operated a business, Riot Foods, which served concessions at festivals and other events throughout Minnesota and Wisconsin from late April into late October of each year. The defendants became interested in purchasing Riot Foods from the plaintiffs. The parties then met several times, and the plaintiffs entered into an oral agreement on August 20th, 2016 for the sale of Riot Foods to the defendants for the price of $170,000. For this price, the defendants received the truck and trailer, equipment, and event contracts from the plaintiff. Following this oral agreement, the defendants immediately paid $15,000 to the plaintiffs. The plaintiffs assert that the remaining balance was to be paid when the defendants secured financing from their bank. However, the defendants assert that the $15,000 was paid for the right to continue considering purchasing the business because the plaintiffs had another interested buyer. Regardless, the defendant, Luann, testified to orally agreeing to the purchase of Riot Foods for $170,000, but then later testified that she could not specifically remember making an oral agreement on any particular date. Regardless, the defendants then took possession of Riot Foods after August 20th and operated it through the business's last event on October 18th. In total, the defendants operated the business at 8 events. Gene helped the defendants at the first 2 events, working as an employee for them and receiving $20 an hour for his services. Ultimately, in late October, the bank approved the defendants for a loan. Defendants, however, concluded that the business was not for them and opted to abandon the purchase. Based upon these facts and the conduct of the parties, the plaintiffs assert that under Section 2-204 of the UCC, the parties intended to form a contract for the sale of Riot Foods. A contract was formed, and the defendants breached that contract by failing to pay the agreed-upon purchase price of $170,000. Under Section 2-204, Subdivision 1, it states that a contract for the sale of goods may be made in a manner sufficient to show an agreement, including conduct, by both parties which recognizes the existence of such conduct. It is the plaintiff's position that this requirement of contract formation is satisfied given the conduct of both parties. Specifically, the parties orally agreed upon a purchase price of $170,000 and a down payment of $15,000 was paid from the defendants to the plaintiffs. The defendants then took control of Riot Foods and operated the business throughout the remainder of the event season. And moreover, it appears the defendants fully anticipated purchasing the business given the fact that they applied for and were approved for a loan. Given this conduct, a court will likely find Section 2-204, Subdivision 1 satisfied. Furthermore, under Section 2-204, Subdivision 2, it states that an agreement sufficient to constitute a contract for sale may be found even though the moment of its making is undetermined. Therefore, under the UCC, it is immaterial that defendant Luann could not recall specifically making an oral agreement on a particular date. Therefore, the agreement to contract is not invalidated due to Luann's inability to recall the date of agreement to the purchase price of Riot Foods. Lastly, a court will look to Subdivision 3 under Section 2-204 to determine if a contract was formed between the parties. This section states that even though one or more of the terms are left unopened for a contract for sale, it does not fail for indefiniteness if the parties have intended to make a contract and there is a reasonably certain basis for giving an appropriate remedy. Under this rule, a contract will not fail for indefiniteness if the parties intended to make a contract and there is a reasonably certain basis for providing a remedy. Here, the plaintiffs assert that the parties intended to make a contract given the conduct described of both parties above, and moreover, there is a reasonably certain basis for providing a remedy for the breach. Again, the key question at issue here is if a contract was formed. Under the UCC, the court will look beyond the formalistic common law requirements and look to see if the parties intended to form a contract. For the reasons previously stated, the plaintiffs assert and believe that the parties intended to form a contract was formed, and the defendants breached the contract. For this, the plaintiffs would urge the defendants to settle this matter in mediation before proceeding to litigation.